Thank you, Adam, and welcome, everybody. Thanks for joining us today. As Adam said, we're going to have a little discussion about workers' compensation, paid family leave, and disability insurance, and what you need to know as a business owner. The Advocate for Business Office was created out of legislation so that business owners, particularly small business owners, would have one place to go to assist them with their problems that they might have regarding workers' comp, disability, and paid family leave. My office handles calls on a daily basis where we assist businesses with coverage and compliance problems. I personally and my staff travel the state prior to COVID. We'd go from Montauk to Buffalo, educating business owners and government personnel, code enforcement people, on the workers' comp system and what they need to know. Also, when we're out, we listen and we hear what business owners are saying, and I go back and I report directly to the chair of the board, and perhaps systemic changes can be made based on what I've learned out in the field. So let's get started. What is workers' compensation insurance? Well, in New York State, it's a mandated insurance that covers on-the-job accidents, injuries, and illnesses. And it provides medical treatment for that accident, injury, or illness, and a partial wage replacement. It protects you, the employer, because 9 out of 10 times there is no lawsuit. There is no need for you, the employer, to hire an attorney because there's no litigation. The injured worker is being taken care of. They're getting their medical treatment and their lost wages. New York State disability benefits insurance, not to be confused with Social Security disability benefits, covers off-the-job accidents, injuries, and illnesses, and it is also mandated in New York. It provides only limited wage replacement. There is no medical benefits attached to disability benefits insurance, and employers can receive a wage replacement of up to a maximum of $170 a week, and that's also up to 26 weeks. So who needs coverage and who doesn't? Businesses with employees need coverage. That sounds easy. Well, who's an employee? Basically, anybody providing a service to a for-profit business can be determined to be an employee of that business, and any compensated individual providing services to a not-for-profit, they can also be determined to be an employee of that nonprofit with very limited exceptions, such as clergy or teachers in an IRS-designated 501c3 entity. Well, then who doesn't need workers' comp? A sole proprietor with no employees. It's me working for me, and there is nobody else. Legal partners in a partnership with no other employees are the same as an LLC. If only the people being compensated are members of the LLC or legal partners, coverage is not required. If you have all partners and you hire somebody else that's not a partner or a member of the LLC, coverage is required. A one or a two-person owned corporation with no employees, husband and wife, they want to start a business, each must own one share of stock and together own all the shares of stock and hold the offices of that corporation. There can be no third shareholder or third person. Many times I've seen a family, a husband and wife, have a business and they have health insurance for that business, and they pay a small amount to their child so that their child can be on that health policy. They then need coverage, all right? The key here is there can be no third person. So workers' compensation insurance, how do you get it? What does it cost? How do they figure out how much it costs? Well, first of all, there are about 250 carriers in New York State that sell workers' comp, disability, and paid family leave, one of which is the New York State Insurance Fund, which is a state agency, and it's called the carrier of last resort, but that's not a negative thing. That's because they must write you. You could contact a private carrier like Zurich or Hartford or Farmers and ask them to write your business, and they can say no. The State Insurance Fund must say yes, unless you owe them money. If you owe them money from a previous engagement with them, they will not write you until you pay that bill. Workers' compensation, as opposed to, say, auto insurance, is an estimated policy. The premium is estimated. When you buy a car, you know what the annual premium is going to be, and that's what it's going to be. With workers' comp, it's estimated. You're going to tell the carrier what your folks are going to do, what your employees are going to do, how many you think you're going to have, what you think your payroll is going to be. They will attach a classification code, which is derived from the Compensation Insurance Rating Board, for the type of work that is being done. For example, let's say you're going to have secretarial work, and the class code for that would be, say, 30 cents, and it's applied per $100 of payroll. So it'd be 30 cents per $100 of payroll, and then how large is your payroll? And very importantly is how safely you operate your business. If the average injury rate in your field is 5 a year and you have 10, you're going to be paying more. And conversely, if it's 5 and you have 1, you'll be saving money. Every carrier has administrative costs that they attach to their premiums, so it's always good to shop it around every year and see if you can get a better deal. But that's basically how your insurance is determined, your premium is determined. Some specific coverage issues, we've gone over the sole proprietor, independent contractors, I'll get to in a moment. Family members. Family members need coverage. You're going to hire a family member. If you're not set up in that corporate or LLC or partnership situation, you need coverage. Domestic employees, if you're gonna hire a nanny, someone to come into your home, if they work less than 40 hours a week, coverage is not required. If they work more than 40 hours a week, coverage is required. If they live with you and work less than 40 hours a week, coverage is required. Now, as we talk about independent contractors, I'll give you an example, and you tell me what you think. Jen wants to start a tutoring business. She's going to hire independent contractors, set up a contract with them, pay them on a 1099, and parents will contact Jen to get a tutor for their child. Jen will supply the tutor, and the parents will pay Jen. Jen will then pay the tutor. Do you think Jen needs workers' comp insurance for her independent contractors? Let's take a moment to see. Answer in the chat box. Okay, the answer is yes, a resounding yes. There's nothing independent about Jen and her independent contractors, quote, independent contractors. It reminds me of a story from when I first started here. A restaurant owner hired somebody to come in and cook lobsters. One night a week, he ran lobster night. He hired somebody on a 1099. They had a contract calling him an independent contractor. And one night a week, he would cook lobsters. Well, unfortunately, he was injured, went to the hospital, and the first thing they ask you at the hospital is, did this happen at work? The person said yes, so a claim was filed, and when it went before the administrative law judge, the judge asked the restaurant owner, why don't you think this person should be covered? And he said, well, he was an independent contractor. He only worked for me 1 day a week. I had this contract we agreed upon, and the judge said to him, well, what kind of business are you in? And he said, I own a restaurant, obviously. And he said, well, what did that person do? The person was a cook. Well, there was nothing independent about that. If the restaurant owner hired somebody to come in and fix the air conditioning unit in their ceiling, that would be an independent contractor, but not a cook in a restaurant. Nothing independent about it. So the moral of the story is don't call something it isn't just to fit your wishes, because being an uninsured employer is the worst thing that can happen to you. On the website, on the board's website, wcb.ny.gov, there's a list of the criteria that our administrative law judges will use to determine independent contractor status. If you're thinking about using an independent contractor, go through these. The first one is direction and control. Are you telling somebody what to do, when to be there? Does the person have their own federal employer identification number? Are they truly another business? Go through the 12 or 13 criteria. If you still have a question, contact our office and we'll give you the best information we can. If you're in the construction industry, the Department of Labor oversees something called the Construction Industry Fair Play Act, where workers are presumed to be an employee unless they can prove they have their own business. If you're in the construction industry, I urge you to go to that website and make sure you're in compliance. General contractors under the law are liable for the workers' comp claims of any uninsured sub. So what that means is, if you're hiring a subcontractor, you want to make sure that they have workers' comp insurance and that you get a certificate of their insurance, because with workers' comp, remember I told you about the premium that is estimated? Well, after a year, your carrier is going to look at your books. And if you've hired somebody that's a subcontractor that didn't have workers' comp, they would be responsible, so they're going to add that cost to your premium. If you provide them with a certificate of insurance, they cannot. I recommend that you get added as a certificate holder on that subcontractor's policy, so that if they lapse their coverage while they're working for you, you will be notified and you can take them off the job until they have the proper insurance in place, so that you're not assessed an amount of money at the end of the year because they did not have that coverage. If you were supposed to have workers' comp insurance and you didn't, we will catch you. And the penalties are up to $2,000 for every 10 days that you didn't have it, or $72,000 a year. If you have up to 5 employees, it's a misdemeanor with an additional fine of up to $5,000. More than 5 employees is actually a Class C felony, and that's subject to an additional $50,000 penalty and even jail. Misclassification is the same as being uninsured. So what's misclassed? I told you earlier, the way you get your insurance is by telling your carrier what your employees are going to be doing. They give a class code. Well, if you get an unscrupulous person that knows they need to show proof of workers' comp, they'll tell the carrier that everybody working for them is doing clerical work. So they'll get a very inexpensive workers' comp policy, when in fact, those people are doing very dangerous asbestos removal. That is an egregious penalty. It's the same as being uninsured, and there are severe penalties for doing that. And my office will not assist anybody to try to negate that penalty. There's also something in New York called the debarment law. And what that means is if you have any penalty with the Workers' Comp Board whatsoever, you will be barred from being awarded any contract with the state of New York for 1 year. There's no way out. And I urge you, so many businesses are on the debarment list for unintended, as an unintended consequence of a mistake. Not everybody is a willful violator. An example that occurs all the time is when a business gets audited by their insurance carrier and they disagree with the audit and they fight with the carrier and they end up lapsing their coverage because of that fight. They end up being told by the carrier that they were correct, but yet now there was that lapse. Because of that lapse, they're now on the debarment list. And if what they do is reliant on getting contracts with the state of New York, they're out of luck for a year. And again, there is no way out. So if you have a dispute with your carrier, pay the bill. If you're right, you'll get your money back. If you're wrong, you should have paid it. But regardless, you will not lapse your coverage and end up on this debarment list. There's nothing that you can do to get off the debarment list. Next slide. If you do have a penalty, we realize that there are many, many times penalties are for unintended reasons. The bookkeeper gets sick. You lost something in the mail. There's an appeal process. Contact the board. If you're penalized, don't stick your head in the sand. It's not going to go away. For example, let's say you hired a nanny and you didn't know you needed the coverage, and it took us a year to find you. You contact my office. I'll ask you, do you still have the nanny, and do you have insurance? And you'll say, yeah, we got the insurance as soon as we know we needed it, as soon as we knew. So I would ask you to send me a note just stating that you didn't know you needed it. Once you found out, you got the insurance, and send a declaration page of your coverage, which shows me the amount of money you're paying for your premium for that nanny. The premium for a nanny is about $400 a year. If it took us a year to find you, you would be in our judgment status, which is the most egregious we would charge a penalty. It would be 4 times the cost of premium for the period that of lapse, which would be $1,600, not $72,000. So again, you can see that it's a fraction of the penalty if you come into compliance. The board's goal is compliance. It's not to collect large amounts of money in penalties. So if you have a penalty, you know someone has a penalty, contact our office. We can work it out with you. To control the cost of your premium, make sure you're in the right class code. You can appeal your class code if you think it's not proper with your carrier. And if they disagree with you and you still think you're right, you can appeal it to the Compensation Insurance Rating Board. They will make a determination, and that code that they decide is correct will be applied. If somebody has a claim, follow it. Stay in touch with your carrier. See if you can get your person back to work on light duty. Do whatever you can to speed up the process to get your employee back to work quickly. And then most importantly, operate safely. One of the ways to do that would be to form a labor management safety committee where you get members of labor and management together, you meet monthly, you rotate the chair, and you walk the workplace, you review your equipment, make sure that the proper procedures are in place. Most accidents occur when shortcuts are taken, and nobody knows shortcuts better than the people doing it on a daily basis. Management doesn't know. So by meeting with your workers, working together, you can establish a safe workplace for everybody, and that will result in lower workers' comp premiums. The Department of Labor also oversees something called Code Rule 60, a workplace safety prevention incentive program. And what it is a voluntary establishment of either a safety, drug and alcohol prevention, or return to work program. If you have all three, you can actually save 10% of your premium the first year and 6% in following years. Labor oversees it. The website's here. Go on it, check it out, see if it's something that you think would assist your business. The Department of Labor will also do a free on-site consultation visit for you. They'll come, they'll walk your workplace. They're not going to look for violations of any sort. They're only going to come to look and help you mitigate safety risks. And again, there's no cost for it. Here's how you contact them for that program. So your employer responsibilities, you have to buy the insurance, workers' comp and disability, paid family leave insurance, display the poster you get. If you have a claim, report it timely. Our law, Section 120 of our law, states that an employee cannot be discriminated against for filing a claim. You can't take action against your employee because they filed a workers' comp claim. Employees can only be terminated for a valid business reason. They can't be terminated because they filed a claim. With workers' compensation insurance, if somebody is out for a period of time and you need to replace them, you can, all right? We urge you to try to keep them, to do whatever you could to keep them, like I said before, bring them back on light duty, whatever you can do so they don't lose their job. But if you must replace them, you can. And lastly, employees are eligible regardless of their citizenship or their immigration status. In 2018, New York State paid family leave went into effect. And what it does is it provides job-protected paid time off to either bond with a child, care for a sick family member, and assist family members who are in the armed services when they're being deployed overseas. In 2023, as it relates to the sick family members, siblings will be added. Right now they're not, but they will be added. And again, the key word was job-protected paid time off. As opposed to workers' compensation insurance, you cannot terminate somebody that is out on paid family leave. All private employees are required to provide it. The employer buys the policy as part of their disability benefits package, and they can deduct the cost from the employee's paycheck. Unlike workers' compensation insurance where you cannot, here it's the way to go. You deduct the cost from the employee's paycheck unless you want to do it and pay for it yourself. The employee pays the cost of the insurance. If you're a sole proprietor or self-employed individual, you can voluntarily opt in within the first 26 weeks of starting your business. There's no waiting period. However, after 26 weeks, there's a 2-year waiting period. Again, who pays for it? It's fully paid for by employee payroll contributions unless you choose to pay. The New York State Department of Financial Services will set the employee contribution rate to match the cost of the coverage, and all of the information, the cost information, deduction calculator, and anything you need to know about paid family leave can be found at paidfamilyleave.ny.gov, and this /cost for this particular situation. Your responsibilities is to obtain the paid family leave coverage from your carrier and pay that premium, provide information about paid family leave to your employees, provide wage information to the carrier if and when an employee requests paid family leave. Paidfamilyleave.ny.gov has all the information you need. With COVID-19, if somebody comes to you and says they've got COVID-19 on the job, you must report it to your insurance carrier. They'll file a claim with the board. There is new COVID-19 quarantine leave, which provides workers with job protection and financial compensation when they or their minor dependent child are subject to a mandatory or the precautionary order of quarantine or isolation. Most employees are going to get the financial compensation by using a combination of the benefits, which may include the employer-provided paid sick leave, depending on the size of the employer, paid family leave, and disability insurance. Your role in implementing COVID-19 quarantine leave, it's basically the same as paid family leave. There are some new forms at paidfamilyleave.ny.gov/forms. Again, visit that paidfamilyleave.ny.gov/COVID-19 for full details. The COVID-19 quarantine leave for most employers with 10 or fewer employees and a business net annual income of less than $1 million, employees can use a combination of PFL, paid family leave, and disability benefits. After receiving their full paid family leave benefit of up to $840.70 a week, employees will receive disability benefits to match their full wages up to a maximum weekly disability benefit of $2,043.92 for a total of $2,884.62 per week. There's no waiting period for either benefit. Employees will have job protection for the duration of the quarantine. For most employers with 11 to 99 employees and a smaller employers, 1 to 10 employees with a business net annual income greater than $1 million, you're required to provide at least 5 days of COVID-19 paid sick leave. After that, the employees can use a combination of paid family leave and disability benefits. After receiving their paid family leave benefit of up to $840.70 weekly, employees will receive disability benefits to match their full wages up to a maximum weekly disability benefit of $2,043.92 for a total of $2,884.62 per week. And there's, again, no waiting period for either benefit, and the employees will have job protection for the duration of the quarantine. For most employees with 100 or more employees, as well as all public employers, you are required to provide at least 14 days of COVID-19 paid sick leave, and employees will have job protection for the duration of the quarantine. There are some COVID-19 premium-related reductions out there. For example, if your payroll is dramatically lower because of COVID-19, report that to your carrier and you're going to get a refund. If you've purchased PPE, personal protective equipment for your employees, advise your carrier. I think there's a rebate of up to $500 for that. And if your employees are now doing work differently than what they were classified originally for, if they're doing clerical work in the home now as opposed to what they were doing, they may qualify for the telecommuter reassigned employees class code, which will reduce your premium as well. Check with your carrier, and they'll let you know if you qualify for that. For more information on paid family leave, there's the helpline on the website. Here at the board, we're very excited. We're building a new business information system, and we call it Onboard. And what it's going to do is give access to real-time claim status for all of the players in the system. It's going to speed up the delivery of benefits to workers and get them back to work sooner than later. And it's going to help everybody, businesses, employers, and injured workers. If you want to follow us on the internet, here's the best way to do it, on social media. And my direct line, my office desk is 518-486-3331. That's my direct email and our website. And at this point, I'll take any questions you might have.